Hi, my name's Aaron Lacey, and I'm the chair of the higher education practice at Thompson Coburn LLP. You are listening to an introduction to managing Title IX sexual harassment on campus. So that you know, Thompson Coburn is a law firm, a large one. We have offices across the country, and we're all attorneys. So the folks who are participating in this free training series for Title IX professionals and those participating in the new Title IX process, we are all attorneys in practice at this law firm. We have a higher education practice, so the folks you'll be hearing from either are part of that practice or work with that practice on a regular basis. And today I'm delighted to be joined by my friend and colleague, Scott Goldschmidt, who you'll see a picture of him in just a little bit. We wanted to tell you first, though, about the purpose of this training series. This is likely the first in the series of the videos that you'll be watching. So as you may know, the U.S. Department of Education promulgated or published a new federal regulation concerning Title IX that becomes effective August 14th, 2020. And one of the things that institutions are required is to train the individuals on campus who will be participating in their Title IX processes on a go-forward basis. This training series that we've created is what we'll call, or are calling, a foundational training series. There's no doubt that you will want to engage in some additional training at your institution to look at and read carefully and familiarize with your institution's specific policies concerning Title IX. And we also recommend things like simulations, where if you're a hearing officer, you actually go through a mock hearing, or an investigator, you go through a mock investigation. These 6 training modules are designed to be foundational training. So for the folks who are going to be participating in this process, as well as Title IX coordinators and counsel who may already have some familiarity, we're trying to help you understand the basics of the new rule. We say basics, there's a lot to take in. That's why there are 6 sessions. But hopefully you can use these. Something else we'll point out, under the new law, institutions are required to put all their training materials on their external websites. We are very happy for institutions to use these trainings. They are free. This whole thing was designed, among other things, so that if schools wanted to use this training for that purpose and to post it on their websites, they are absolutely welcome to do so. And if you'd like to talk to us about some custom training, of course, we're happy to talk to you about that as well. I mentioned earlier, the series is comprised of 6 different modules or sessions, if you will, and each session will show you this slide, and the orange box will tell you which session you're watching. And so if you're watching this video, you're currently, as I mentioned earlier, watching Introduction to Managing Title IX Sexual Harassment on Campus, and this is the first session in the series. Within this session, we'll also be providing or going through this sort of outline, and each time we start a session, we'll have what we call the syllabus for the session. So you can see here the topics we'll be working through today, and that includes some introductory material around Title IX and the new rule and how it relates to sexual harassment on campus. And then Scott will go into key definitions, responding to allegations of sexual harassment on campus and the elements of a sufficient response. Then we'll take a little bit of time to talk about the formal complaint and some other additional considerations. So I mentioned earlier, my friend and colleague Scott Goldschmidt is with us today. Scott actually, and this is an important note for you all, was the Deputy General Counsel at Catholic University and was in-house there for about a decade. And we highlight that because we know, for those of you who are on campus, that being on the other side of these sessions and having to really learn and implement these new rules on campus is a difficult, challenging task, and it requires a certain perspective. And Scott brings that perspective. It also helps that while he was at Catholic University, he did a great deal in the Title IX arena, from drafting policies to working through investigations and hearings and things of that nature. And as I mentioned, I'm the chair of the higher education practice at Thompson Coburn and have been in and around colleges and universities and working with them for about 20 years, including in areas of discrimination. So moving right along, let's talk about first the Title IX statute. So now you see we're in the Title IX fundamental section of the presentation. You know, or some of you will know, if you are an administrative law type person, that when we talk about the statute, we're talking about the laws that were actually created by Congress. So this is the original statute that came out of the House and the Senate back in 1972 as part of the Title IX, when we say Title IX, we mean of the Education Amendments of 1972, and it generally prohibits discrimination on the basis of sex. A few important points to make. First of all, there's not a lot in the statute. You may have read in the press and seen a lot of discussion around Title IX, particularly in recent years. The statutory language itself is pretty lean, and that's why on the next slide we're going to talk about what the U.S. Department of Education has done in the way of regulations. But what is important to note about the statute is that it is not limited to sexual harassment. It prohibits discrimination on the basis of sex in all programs and activities of an institution. So you see some bullets here, and this is a really important point because we're going to talk about, and I have a slide in a minute where you'll see, and we'll be emphasizing this throughout this entire series. You know, Title IX, when you talk about the big picture, the statutory language, prohibits discrimination on the basis of sex throughout the institution. So if someone were to come and say, you know, I feel like this individual was promoted over me and I was discriminated against based on my sex, that's prohibited under Title IX, but that's not sexual harassment, right? It's a form of discrimination on the basis of sex. The new rule is really focused on sexual harassment and in particular formal complaints of Title IX sexual harassment. So we'll get to that in a minute, but the key point I want to make right now here at the outset is Title IX is bigger in scope. It prohibits all forms of discrimination on the basis of sex at the institution. It's also important to note it protects both students and employees. So for a very long time, we thought, and you'll see the first bullet here, when we thought about Title IX, we were primarily thinking, most people, about equity in athletics, right? And that not only keeps us in that sort of athletics bucket, but it also tends to get us thinking primarily about students. Well, Title IX does protect students, and it certainly applies to athletics as well as other educations and programs of the institution, but it also prohibits discrimination on the basis of sex with regard to your employees. So it protects and covers both students and employees. And one of the features of this new rule is it has really emphasized this idea that all of these requirements around the management of Title IX complaints on campus also need to be adhered to, even when the complainant or the respondent is an employee. But we wanted to go ahead and let you know now the Title IX statute is actually pretty bare bones. And you'll see at the bottom of each screen here, when we're talking about a particular statute or regulation or some commentary from the Federal Register, we include a citation for you. If you were to go to the citation in the United States Code for Title IX, you might be shocked at how little is actually there. There's the general prohibition on discrimination based on sex. And beyond that, there's not a lot of detail. Most of the detail is in the Title IX regulation, which was created by the U.S. Department of Education. The regulation, and this is often the function of regulations, amplifies the statute considerably. So it gets into all of that detail. Congress said, we're prohibiting the discrimination on the basis of sex at colleges and universities. Now, Department of Education, we want you to go and expand on this concept, right? And so they did that. And if you were to look at the regulation, and that's in 34 CFR Part 106, you see down at the bottom of your screen there, you'll find lots and lots of information about what is specifically prohibited and the expectations of the department. Among other things, sort of the key concepts that the department for a very long time has suggested are required under Title IX. You have to disseminate a policy, which includes a non-discrimination statement. You have to designate a Title IX coordinator, right? Adopt and publish grievance procedures. And so this is a process, right? A complaint process or a process to resolve complaints that allows for the prompt and equitable, adequate, reliable, and impartial investigation of complaints. And this is all in the regulation. These are sort of your core obligations under the regulation as an institution. And then finally, there's an expectation that you have to take action to address and prevent sex-based discrimination. Of course, the question becomes, well, when you get into the details, what is it exactly that an institution has to do if it's complying with these sort of 40,000-foot obligations? And that's where we get into a lot of the nuance that you're going to see in the rest of this presentation and in the rest of the series, I should say. It's also worth noting that the Title IX regulation, well beyond just prohibiting sexual harassment, right, prohibits discrimination on the basis of sex in a range of specific activities. So if you're a student, for example, in the regulation, it says, look, institutions can't discriminate in admissions and in recruitment and in housing and facilities and counseling and all these different aspects of the institution. Similarly, there is a section in the Title IX regulations that explains and expounds on the particular prohibitions for discrimination with regard to employees. So it says, look, if you're an institution of higher education, the regulation says you can't discriminate on the basis of employment or recruitment or compensation or job classification or employment criteria when you're thinking about your employees. Once again, that would be faculty and staff. So where does the new Title IX rule come in? And you may have seen a lot in the press. There's been a lot of conversation around that. We wanted to take you back a little bit and give you some perspective. By the way, if you pull down the slides for this presentation, so if you're listening right now, you're probably watching the video, right? But you can also get the slides, and if you have the slides, anywhere you see that dark red underline, that's an active link. So we wanted to make sure that you could access these underlying resources if you're interested. So if you are counsel, if you are a Title IX coordinator, or just a curious advisor or adjudicator and you want to pull these resources together, this slide, for example, has a lot of links where you can go and get the underlying resources. So in 1972, way back when, over 40 years ago, that's when the department created the Title IX statute. Talked about that a minute ago. And then 3 years later, the Department of Education promulgated those regulations I was just referencing, where they got into all that detail around the different types of areas where institutions shouldn't be discriminating on the basis of sex. What's interesting is you'll note there's here a huge jump, 22 years to 1997 before you see any real additional activity. And it was at that point for the first time, maybe surprising to some, that the Department of Education put out sort of a meaningful set of guidance and guidelines around, in particular, sexual harassment on campus, which of course is a form of discrimination based on sex. So to be clear, you had over 20 years that went by after those initial regulations were created before the department got particularly into this issue of sexual harassment on campus. After they put out that guidance, there were some individuals who were at institutions who felt like the college and university, based on the guidance, was not getting it done under Title IX. And remember, this is important, Title IX places obligations on institutions, not on students and their employees. Title IX governs the institution and says the institution can't discriminate on the basis of sex. So you had individuals who were at institutions who said, well, I don't think my college or university complied with Title IX. I don't think they got it done, at least with regard to my particular issue. And two of these matters made it to the Supreme Court, and the Supreme Court considered the extent to which individuals could bring a claim in a private action and argue that their institution failed to comply with Title IX, and the extent to which they could recover some type of reward or compensation based on the institution's failure. And the Supreme Court said, yeah, there is a private right of action. If colleges and universities fail to comply with Title IX, individuals can bring lawsuits. And many of you are probably aware of that because there have already been a number of lawsuits, particularly in the last 4 or 5 years, that continue to push and test the bounds of Title IX and push institutions to do more. So that was in 98 and 99. You had these two big Supreme Court cases. 2001, right around the corner, the department says, okay, now we've got these Supreme Court cases and we've got these thoughts that came from the justices. So we're going to go back and issue a new set of guidance, another big document. And it's going to talk about, again, what colleges and universities and elementary and secondary schools, frankly, covered by Title IX, what they need to be doing to respond to sexual harassment that may occur on their campuses. And so one of the things I wanted to point out here is while the Supreme Court decisions represent law, the 2001 pamphlet, which is significant, was labeled significant guidance by the Department of Education, which is a concept in the federal government. When you have a really big document like that, they'll literally label it significant guidance. It was guidance, but it wasn't law, right? So it's not a statute. It's not a regulation. It was still sub-regulatory guidance issued by the department. And this is an important point. In 2000 and 2006, there were a couple of additional pieces of guidance that came out. And then in 2011, the prior administration, this is right now, it's July 2020. So when I say the prior administration, I mean the Obama administration, in 2011 issued a Dear Colleague letter that really shook up higher education and elementary and secondary education, because it was, again, guidance, but it offered a lot of additional thoughts specifically for how institutions should be managing and responding to allegations of sexual harassment or sexual violence on their campuses. And this was a wake-up call for institutions around the country. If you were at an institution in this period, you may remember that. Certainly the Title IX coordinators and the councils at institutions were paying attention, because this guidance suggested that colleges and universities should be doing a lot more, candidly, than many of them were doing back then. Rightly or wrongly, it was still more than what they were doing. And a lot of them changed at that point and started putting processes into place and revising their approach to managing allegations on campus. At the same time, the Office of Civil Rights started launching additional investigations, some of them quite high profile investigations of institutions. So there was a lot of discussion, which is why a few years later in 2014, the Obama administration issued some additional guidance, because there were all these questions that had come up since 2011, and colleges and universities saying, we need to know more. If you're going to tell us we have to do all this extra stuff, then that raises a lot of questions, and we need additional clarity on how we should be approaching and complying with what you said in 2011. And then finally in 2016, as I'll call it sort of transgender bathroom debate raged, and you had state's attorneys general get involved and the administration take a certain position that some states didn't agree with, the department responded by issuing additional guidance, yet again, on how colleges and universities should be working with and potentially accommodating transgender individuals on their campuses. Now, you see, I put a yellow or gold box around those three pieces of guidance. And the reason I did that, and this gets to the idea of the difference between statutes and regulation and guidance, is because guidance, unlike statutes and regulation, is not subject to the Administrative Procedures Act. And what I mean by that is a subsequent administration can't just say we don't want to enforce a statute or we don't want to enforce particular regulations. If they want to remove those regulations or modify them, they have to go through the Administrative Procedures Act, which means they have to go through a rulemaking, and that takes a lot of effort and time. But it's really easy to rescind guidance because it's not law, it's just guidance and interpretation. And that's what happened. We got a new administration in, the current Trump administration, and they said, we don't like all the stuff that was in that gold box on the prior slide, so we're going to take it off the books. Okay, how does all that bring us up to the point of our presentation today? Well, all of this is to say, remember, way back in 1972, we had the statute, and 3 years later, we had that regulation. The fact of the matter is, since 1975, when the department promulgated those initial regulations, there has not been any new meaningful regulation, law, again, regulation, governing sexual misconduct or allegations of sexual harassment on campus, at least not under Title IX. And while you had all this guidance that came out back in 2001, and then from the Obama administration, and even when the Trump administration rescinded the prior administration's guidance, they offered up some new guidance. The fact is, none of that constituted law. And the reason I point all this out is because it's to highlight the fact that this new rule that goes into effect August 14th, 2020 is actually the first significant, meaningful law from either Congress or the U.S. Department of Education governing sexual harassment on campus really since 1975. So it's been over 40 years. And it is a large and complex rulemaking. The unofficial version was over 2,000 pages, so there's a lot to parse, which is why we've got a 6-module training series designed to help people sort of figure it all out. All right. If you are interested in seeing the new rule, by the way, it's pretty easy to do. You could probably just Google, Title IX to 2020 Federal Register. But if you have the slides, again, the good news is we've created a lot of links for you. So where you see an image like the one here that's got the black outline around it, looks like a web page, which it is, a screenshot of a web page. You can just click on that image and it will take you to the new rule online on the Federal Register's website. Okay, so again, I want to emphasize here at the outset, because this is really important, and it's going to be important for you to keep in mind as you go through the rest of these trainings and as you go forward and serve as an investigator, adjudicator, Title IX coordinator. This concept, this big picture is always important to keep in mind because it helps you understand where the new rule really fits into the context of the statute and Title IX in general, right? So we started out, and you're going to see this graphic a lot. It comes up in every one of our presentations just to remind people, right? So the big picture, you've got discrimination based on sex. The statute prohibits discrimination based on sex at colleges and universities. And pursuant to that statute and the regulation, you see the site here echoes this general obligation. Schools are required to adopt and publish grievance procedures and processes for managing promptly and equitably any form of prohibited sex discrimination. So again, just to be clear, if someone says, look, I feel like I should have gotten a promotion and this other person got a promotion because that person is a man and I'm a woman, or vice versa, that's an allegation of discrimination based on sex. And schools have to have a process in place to equitably and promptly manage that complaint or allegation, right? So within that, you've got what I'm going to call, and we're going to call for purposes of this series, Title IX sexual harassment. Right? So the U.S. Department of Education in this new rule is really focused on sexual harassment, right? So we got the big bucket of discrimination based on sex, and then we have a more specific bucket of unwelcome conduct of a sexual nature that constitutes Title IX sexual harassment. And Scott's going to talk about in a little while. One of the features of the new rules, we have a definition of sexual harassment now in the Title IX regulations, which we call in the biz Title IX sexual harassment. And the reason we call it that is because it might differ a little bit from other definitions of sexual harassment that appear in other places in federal law, like Title VII, the Civil Rights Act, or in state laws, right, which you will still have to comply with if you're in a state that has a state level sex discrimination type statute, which many, I'll say most, do. But anyway, getting back to our point here, so you've got the general obligation under Title IX to address discrimination based on sex, and you have to have a process for doing that, right? And now under the new rule, you have an obligation for addressing what we call Title IX sexual harassment. And that ups the game a little bit, meaning there are some additional requirements. If there's a complaint made and it constitutes Title IX sexual harassment, right, then in an education program or activity, so this definition of Title IX sexual harassment has some parameters around it, but if it qualifies, you as an institution have an obligation to have a process in place and to do certain things. And then within that, we have this really specific concept of a formal complaint of Title IX sexual harassment. And in fact, most of this training series is focused on formal complaints of Title IX sexual harassment. And most of the new rule is focused on the management of formal complaints of Title IX sexual harassment. So if you get a formal complaint, we're going to talk about what that is later in this presentation and in other subsequent presentations. If you have a formal complaint, then again, as an institution, you have some very specific obligations. And it's in the context of the formal complaint of Title IX sexual harassment that you're going to have your advisors and investigators and adjudicators and Title IX coordinators and appeal officers, all those folks really get engaged, right? The Title IX coordinator may be involved in all of these, but the remainder of those roles, you're probably only going to get involved significantly if it's a formal complaint of Title IX sexual harassment. All right, so with that, I'm going to turn it over to Scott to start you through some of the key definitions introduced in the new rule.
All right. Well, thanks, Aaron. And I think best way to start with that great overview is to really just go over what changed, what definitions were included in the new rule that you should be aware of. That kind of sets the foundation of all the expectations that the department has, both for Title IX sexual harassment in general and also formal complaints. And here you see kind of a list of general terms, and I think we'll go through them one by one. So the first and clearly the most important term is sexual harassment. And you'll notice the orange signifies that a term is important and worth kind of paying attention to. And here, sexual harassment, as defined in the regulations, is conduct that meets any one of the following bases. So conduct on the basis of sex that satisfies one or more of the following. So the first is unwelcome conduct that's so severe, pervasive, and objectionably offensive that it effectively denies a person equal access to the school's education program or activity. So just unpacking this really briefly, here the conduct must be unwelcome to the individual. That's the subjective element that the individual has. But the definition also makes clear that that it has to be determined by a reasonable person. So there is a layer of objective analysis that goes into this as well. And just note that severe, pervasive, and objectively offensive is an and, not an or. So all three must be met to meet this first prong. The second prong is referred to as quid pro quo harassment. So if this, then that. So an employee at the institution conditions sexual act, behavior, etc., on an individual's participation in unwelcome sexual conduct. So very brief and crude example, a professor says, I will give you extra credit in your assignment if you go to dinner with me in a romantic sense. That could be quid pro quo harassment. And the last part of the definition is offenses that the department has said just constitute per se sexual harassment. So sexual assault, dating violence, domestic violence, or stalking are also all elements of sexual harassment as part of this definition that would trigger an institution's obligations. And just to back up a little bit, some context on the basis for the new definition. So this is explained in more depth in the preamble, but the departments of education in administrations past have taken the position that the Supreme Court standards that Aaron mentioned, the standards in Gebser, the standards in Davis, don't apply to the department's interpretation and promulgation of the rule. And they've set their policies and standards accordingly. This administration's taken a different tack, and they said, we still have this discretion, and we're going to use it a little bit, but for the most part, we're going to just build upon the established foundations of the Supreme Court, track the definitions for most part in Gebser and in Davis. And one of the main reasons for that is because in the department's view, it doesn't make sense if you're a college or institution to have two different standards, depending on if you're in front of the Department of Education or OCR. So here, by kind of harmonizing the standards and kind of one standard both in the federal sense and for the department sense, an institution kind of has one set of obligations that they need to adhere to if the challenge under the rule. So just to kind of button up a few clarifying questions about the definition. So will this definition prohibit all harassing or offensive remarks? And here we're looking at the first prong of the definition, and the answer is going to be no. So remember, under that first prong, unwelcome conduct must be severe, pervasive, and objectively offensive. So, for example, if you have one really objectively offensive joke that's told by an employee at the institution, that's sure not acceptable. But does it meet severe, pervasive, and objectively offensive? Maybe not. So it might not meet Title IX sexual harassment. But as we'll discuss in this presentation and reiterate many times throughout the series, just because it's not covered under this specific rubric doesn't mean schools cannot address it, either under a code of conduct, or HR manual, or any adjudication process a school has. And for a lot of reasons, schools will want to address this in some way. And so second, does the second two elements, quid pro quo harassment and the Cleary Vawa offenses, and by Cleary Vawa we mean sexual assault, dating violence, domestic violence, stalking, those offenses there. And we call them Cleary Vawa because they're defined under the statutes. So under prongs 2 and 3 of the definition, do they have to be severe, pervasive, and objectively offensive? And the answer here is no. Only the first prong, the unwelcome conduct prong, needs to meet this severe, pervasive, and objectively offensive standard. The departments explain that a victim of quid pro quo harassment or sexual assault, dating violence, domestic violence, stalking, has been effectively denied equal access to education, even based on one incident, and it would be sufficient to meet the definition under the regulation. Next, a few definitions to go over, and to the extent that you've been familiar with Title IX processes in the past, this is a review, but just to make sure we're all on the same page, the complainant here is the individual alleged to be the victim of conduct that could constitute sexual harassment. So here, again, we'll explain this a little later, any person can make a report of sexual harassment. And that's fine, and the institution may or may not have obligations based on that report. But to be a victim, or to be a complainant, you have to be the victim of the conduct. That's just the way the term of art's used. Here, a respondent is the individual who's been reported to be the perpetrator of the conduct that could constitute sexual harassment. So in an adjudication, they'd be the person that is charged with a potential violation of a code of conduct or policy. And consent, we wanted to highlight because as important a concept as consent is, the department's made clear that the regulations are not going to provide a definition. So this is up to the discretion of the schools. with the important caveat that some schools have state law requirements to apply a particular definition or set of standards. So obviously, if you have a state law requirement, please follow your state law requirement. But for every other school, there's really a broad latitude to develop a definition. Acceptable to use the definition that you previously had in your policy if you liked it, or if you didn't like it, time to rethink your policy. But a few things to potentially consider, in a consent definition, and you want to have a robust definition because this could be the crux of a lot of sexual assault complaints. But whether your definition is predicated on words or words and actions, whether it's an affirmative consent standard, whether there's definitions for and explanations of when consent is not acceptable, such as when a potential complainant is intoxicated, and just kind of examples of what could and could not constitute consent to guide your adjudicators.
I'll jump in here too and just offer some folks who are perhaps new to the Title IX process. If you're an advisor or an adjudicator or some other individual that's been asked to participate in this process, maybe even for the first time, you may be listening to Scott and some of these concepts and saying, boy, I mean, am I supposed to go figure all this out? And my response to that would be probably not, right? I mean, the idea is your Title IX coordinator, your HR department, and your counsel inside and outside are looking at these same rules, and they are crafting and thinking through what your institutional policy should be and how you're going to deal with some of these things. So if you're in a particular state, they may already have a definition of consent in their Title IX policy that complies with the state law, and that's the way it'll stay, and nothing will change. It may be they already have definitions of complainant and respondent, and they're updating them to ensure that they're clear and consistent with the new law here under Title IX, but they may already be there in some format and already have some discussion around, well, what happens if we have someone report who's not actually the complainant and, but a reporter, and how do we treat them, and how are our policies going to work if we have sexual harassment that doesn't fit in the Title IX definition, but our institution still wants to address. The good news is, many of you watching this aren't responsible for making those decisions and figuring those things out. What you are responsible for is making sure that if you're a participant in this process, you review your policy very carefully, right? So again, this is foundational training. Our objective is to lay a foundation and make sure you understand what the new law says, how it has sort of come about in the context of the Title IX conversation. In some of our later sessions, we're going to have some great feedback from career investigators and a longtime judge on things like making relevance decisions and dealing with advisors, et cetera. So it's all great, but there's no substitute for studying your own policy, because a lot of this will be thought through carefully by your counsel and your Title IX coordinator. So we encourage you, again, if you decide to watch all these sessions, we're delighted. But even after you've done that, you absolutely have to take time to review those policies and look through and make sure you understand where your institution has landed on these various issues.
That's a great segue, and we're certainly not trying to scare anyone here, trying to demystify the process as best we can. But moving on from definitions, let's talk about responsibilities and how institutions respond to Title IX sexual harassment. So as you can see, there's a lot of orange here, a lot of important concepts, and some of these will be discussed here, others will be discussed in other presentations. But just briefly, so an institution must respond to sexual harassment with or without a formal complaint, which we'll talk about later, what a formal complaint is. First, when the student has actual knowledge of the alleged sexual harassment, and actual knowledge is a defined term that is very important that we'll discuss. Second, the alleged sexual harassment occurred in an education program or activity of the school. Again, another term of art that's very important to the definition. And third, the alleged sexual harassment was against a person physically located in the United States. So let's talk about actual knowledge. So actual knowledge is the standard that the department has said exists to show when an institution is on notice of a potential complaint. If the school does not have actual knowledge, it doesn't have notice. So actual knowledge means notice of sexual harassment or allegations of sexual harassment made to a Title IX coordinator, so that's pretty hopefully self-explanatory, or to an official of the school who has authority to institute corrective measures on behalf of the institution. So we, as a shorthand, we're calling these individuals individuals with authority. And if either a Title IX coordinator or an individual with authority has notice of sexual harassment, the school is considered to have actual knowledge. So a couple things, and we discussed this earlier. Who can make a report? Any person. So the regulations are very clear. This includes bystanders, anonymous reports, parents, the actual complainants. Anyone can make a report to the institution. This important concept of official with authority. So who is an official with authority? It's going to differ between institution and institution. So it's a fact-specific determination. So the preamble that we referenced earlier, that kind of that preface to the regulations that gives the department's thinking on certain issues, it identified that possibly at your institution supervisors would be officials with authority, possibly deans would be officials with authority, but it really is incumbent on the institution to take a step back and determine who at the school would be an official with authority. What you don't want is to have a situation down the road where this is not made clear. There's an argument over who is an official with authority because they're very important. Once you tell an official with authority, then the school has notice. So it's really important to detail who that person is, set that expectation out to your campus community. And we absolutely recommend prior to the regulation, prior to your policy, or the same time as your policy, to publish a list and just say, along with your Title IX coordinators, here are officials with authority that you can go to provide the school actual notice of a complaint. So next we want to talk about which individuals must report sexual harassment to the Title IX coordinator. So other than Title IX coordinators, other than officials with authority, who has to report? And for those that have kind of been in the process for a little bit, this sounds a lot like the old conception of responsible employees. And what the department says here is the institutions have wide latitude to make a determination that they feel is appropriate. So they're not going to have a responsible employee concept because the new standard is actual notice to of officials with authority or Title IX coordinators. But by policy, institutions may want to have a mandate that certain individuals have to report notice of Title IX to the Title IX coordinator. In addition, it's important to note that certain state laws have requirements that either prescribe that certain people must be report sexual harassment, or all employees report sexual harassment. So it's important to look at state law as well as you're crafting this analysis. So the second important prong that we talked about, we discussed, is an education program or activity. So for Title IX sexual harassment to occur, it has to occur in an education program or activity. And that includes locations, events, or circumstances over which the institution exercised substantial control over both the respondent and the context in which the sexual harassment occurs. The department also makes it clear that this includes a building owned or controlled by a student organization that's officially recognized by the post-secondary institution. So I think this clearly was meant to cover Greek life, Greek housing that may be off campus, but is potentially owned or controlled by the institution. But it really would apply to any building that would meet this criteria. Again, determining an education program or activity is a fact-specific inquiry that will change based on your institution. So the key questions to ask are whether you exercise substantial control over the respondent and the context in which the incident occurred. So to the extent that you can do this analysis prior to the situation, we absolutely encourage you to kind of figure out what would be considered your educational program or activities, so that there's no question about where the Title IX sexual harassment jurisdiction starts and stops. As Aaron said, there's also specific trainings that schools must do for for school-specific policies. And this would be a very important thing to train on. What is your institution's program or activity?
Scott, and before we get to this last question I see here that starts to get into some, I think my next question to you actually leads into the last question on the slide. And it is, we're talking about these parameters that show up in the definition of sexual harassment, or Title IX sexual harassment, to be really clear. And you've already alluded to, but maybe it's good to talk a little more now about this idea that there could very well be sexual harassment that occurs and is reported to you that falls outside of this definition of Title IX sexual harassment, either because it's not in a program or activity, or because it's not, doesn't rise to that severe and pervasive criterion or level, or as you're about to speak to in a second, maybe there's a combination of activity and some of it's on campus and some of it's off. And then I think it's on the next slide, but the last criterion we saw earlier was it has to be involve a person physically present in the United States. All of this sort of gets at this idea that there may be episodes of discrimination on the basis of sex, and even specifically sexual harassment, that just don't fit into this box of Title IX sexual harassment. And so it seems like schools are going to have to figure out from a policy perspective how to manage that. And they're going to have to make decisions regarding, whether or not they just want everything Title IX sexual harassment and non-Title IX sexual harassment to be covered under a single process, or whether they want to design different processes, et cetera. What kind of things would influence a school to choose one direction over another when thinking about how to design their policy structure?
Yeah, no, that's a great question. And I suspect a lot of people watching this this is the question that they're grappling with now. This procedure that we're really talking about and stressing is fairly specific and only covers certain things. It's clear that institutions will want to cover a broader sense than that, and will not want to just stop at the bounds of Title IX, because it is pretty limiting, and a lot of offensive conduct and potential violations that a school would want to address are just not covered by the regulation. So just broad strokes, schools have a couple options here. So the first, as you alluded to, is to just take the policies and procedures that we're spending a lot of time drafting and a lot of time going over, and just kind of put everything in the bucket and say, even if it's not Title IX sexual harassment by the rule, for the purpose of our process, we're going to treat it as such. We're going to give it the full formal complaint process that we're going to go through later. The pro of that is it's simpler. It ensures sufficient process for individuals going through the regulation. But as the con is these provisions that we're going to discuss and go through in 6 sessions are fairly onerous, to the extent that schools will not want to address things that are not covered under the definitions in such a robust way. Schools may not want to put them through that whole process, and that's absolutely acceptable. So another thing schools could do is kind of bifurcate, say, here's my Title IX sexual harassment process with all the trimmings that we're going to talk about that are required by law, by these regulations. But if it is sexual harassment that's just severe and not pervasive or objectively offensive, or as you had mentioned too, it occurs outside of the country, we're going to treat it under this bucket with this process where there's no defined rules, except back to our first foundational slide, there has to be a grievance process to address it, because it very well could be discrimination based on sex. So these are not easy decisions. It is not a clear-cut case. There's pros and cons of each way. It's just something schools are going to have to consider.
Yeah, and I'll just add to that, even beyond, as you look at and learn about this new Title IX process, and as Scott mentioned, it's very involved. But involved doesn't necessarily mean better. And the one thing I want to add is it's also entirely possible, and I think likely, that some schools will look at the new Title IX process and say, you know, it is involved, but we don't think that makes it better. There are elements of it that we actually think are problematic, and put, you know, respondents and complainants in situations and dynamics we don't like. We don't like what it requires around advisors. We think that could actually be detrimental to the process. So not only are we going to create a separate process for non-Title IX sexual harassment because we want something that we think is potentially simpler and easier to administer, but we actually think we have a process over here to the side that is better. So when we're not required to follow the Title IX process, we're going to actually follow our process. Again, not only because it's simpler, but because we think it does a better job. And that's a legitimate place for schools to land. And I have no doubt that there are people out there who will come to that conclusion. So a lot of factors in place, Scott, as you pointed out, when folks are thinking about how to structure these policies. And all the more reason, I'm going to keep saying this over and over, all the more reason that the folks listening in need to make sure to read your school's policy very carefully.
Yeah, that's a great point. And just to kind of button up the last question on the slide, if we haven't discussed it already. So if there's a kind of a split situation where an activity, a sexual assault occurred outside an education program or activity, but there's later sexual harassment that occurs inside program or activity, Title IX, strictly speaking, would only cover what happened in the educational program or activity. That being said, depending on your policy, it sounds like you absolutely, for certain cases, would want to address it. It's just how best to do it, and it's a complex kind of set of analysis to figure out the best way to do it. And the last prong we're talking about is physical location. So here, the limitation of Title IX and the statute is the complainant must be a person physically located in the U.S. And here the department's just kind of said, hey, we acknowledge that this is not going to cover a lot of individuals in common situations. So if your institution sponsors a study abroad program and an assault takes place abroad, this process would not cover it. Now, would the school want to address that? Yes, absolutely, but it would not be Title IX sexual harassment as such under this. Just one quick note, though, it appears, though, sexual harassment perpetrated online against an individual physically located in the U.S. could be covered, even if the perpetrator was located outside the country. So moving along, when a school has notice of sexual harassment, what does it have to do to respond? What's a sufficient response? So here, institutions must respond promptly and in a manner that's not deliberately indifferent. That's a key term of art that we'll explain right now. So a school is deliberately indifferent only if its response to sexual harassment is clearly unreasonable in light of known circumstances. So deliberate indifference is a standard set by the Supreme Court in the cases we discussed earlier, and the department's adopted that standard as well for its analysis. So schools have to be deliberately indifferent in order to violate Title IX. It's a high standard, but there are certain ways that it's certainly possible to meet a deliberate indifference standard, and schools should not use that as kind of a crutch to say it's too high, I'm never going to be found to violate this because it's just such a high standard. So the proposed rule, the department offered detail on what conduct would or would not constitute deliberate indifference. So the final rule doesn't include that language, but as we'll discuss in the next few slides, there are elements of the final rule that the department does point out as constituting a sufficient response. And theoretically, an institution may be deliberately indifferent if it does not follow these. So some of those include the Title IX coordinator promptly contacting the complainant to discuss the availability of supportive measures, the Title IX coordinator's consideration of the complainant's wishes with regard to supportive measures, the coordinator informing the complainant of the availability of supportive measures, so regardless of whether a formal complaint is filed, and explaining the complaint process for filing a formal complaint. So hopefully these elements are things that your institution's already doing in some fashion or another, and this is just a refresher and extra emphasis to get this part done. So next, the final rule specifies a school's response must treat complainants and respondents equitably. Equitable treatment is a big part of the regulation, the preamble. It's a big thrust of it. Through everything, complainants and respondents have to be treated the same. And here we're talking about by offering supportive measures to a complainant and by following a grievance process before the imposition of disciplinary sanctions against a respondent. So as we discuss here, these are specific terms called out in the regulations, and potentially not following these could be evidence of deliberate indifference. So as we discussed earlier, it's not a crutch here. It's not an insurmountable standard. So does deliberate indifference relieve recipients of their obligation to respond to every known allegation of sexual harassment? No, the standard doesn't. Institutions should absolutely respond, as I'm sure every institution would want to. Next, in the absence of a formal complaint, so where are there circumstances where an institution would initiate a grievance process against a respondent to avoid being deliberately indifferent? And the answer here is yes. So if there's no complainant there to file a formal complaint against a respondent, there are absolutely situations where a school would want to consider whether they would want to initiate a grievance process in order to meet its obligations under Title IX. So the preamble explains a few of these. Threat, violence, weapons could be, but most significantly, a serial predator. So to the extent that a complainant comes to a Title IX coordinator and says, I want supportive measures, but I don't want to file a formal complaint, that's one analysis. If 2, 3, 4 complainants come with the same respondent and don't want to file a formal complaint, that's a different analysis, and that may require filing or the Title IX coordinator kind of taking matters into its own hands in order to ensure a safe and non-discriminatory environment for students if a serial predator does exist on your campus.
Interim and supportive measures. We've grouped these together, but they're really different concepts. When we're talking about interim measures, we're talking about things that an institution might do not to support the complainant or respondent, but more, although frankly, interim measures could be taken for that purpose, I guess. But what we're really talking about is removal and administrative leave, right? And this happens if you're at an institution and you've been in the Title IX process for a while, or you're in the HR vertical. Everyone ultimately has a situation where before they're able to go through the investigation and hearing process and reach some determination on whether allegations are true, they may feel like for various reasons they need to remove someone from the campus. And what the new rule says is there is an allowance for that, right? And Scott mentioned earlier, this new rule, this administration was very focused on, in their view, creating more balance between complainants and respondents, and they're very committed to this idea of not penalizing respondents until that investigation and hearing phase, that formal process has been completed. But there is a recognition that there could be situations where removal or some sort of administrative leave is appropriate and necessary. So what this administration says is you can do it. That's what the new rule says. But if you are going to do it, you need to make sure that you are following certain criterion. And the criteria here, the school has to undertake an individualized safety and risk analysis. So you can't have a blanket policy that anytime a certain situation arises, you're going to send somebody home. It needs to be a specific analysis of the circumstances at hand. If the institution determines that an immediate threat to the physical health or safety, note emotional health and safety is not included, or mental health and safety, it's strictly the physical health and safety of any student or other individual arising from the allegations of sexual harassment. And importantly, that's an and, it's conjunctive. So all three of these have to be satisfied. And the institution provides the respondent with notice and an opportunity to challenge the decision immediately. And our advice is, if you are considering sending somebody home or removing them, you should already have some sense as to what that challenge process is going to look like so that you can notify them and make sure that you can run the challenge process efficiently. You don't want to send them home and then weeks or months to go by before they have an opportunity, because they're being harmed, right? I mean, they're not able to work, they're not able to attend school. It is punitive in that sense. So you need to afford them their opportunity under the law to challenge in a timely manner. An institution would be permitted, and this is also specific in the new rule, to place a non-student employee respondent, meaning when you say non-student employee, we mean if you have a work-study student, for example, they might be an employee, but they are a student employee. So we're talking about strictly non-student employees can be put on administrative leave during the pendency of the grievance process. Scott, you keep flashing in. So much going on there in DC.
Yes.
For folks on the line, I'm in the Midwest. I'm in St. Louis, Missouri, and Scott is in our Washington D.C. office. I mentioned earlier, this is July 2020, so we are operating under and still amidst the pandemic, and so we're operating out of different offices and in some cases out of our homes. Scott, a couple of good questions here that were raised around these interim measures that I will actually shoot to you. Would be interested in your thoughts, sir.
Absolutely. So regarding the first one, just to build off what you said in the last slide. So I think you correctly mentioned that you should really have an idea of what your challenge process looks like prior to undertaking this. And I'd just like to add, you should also have a process of what your analysis process it should be prior to undertaking it. You don't want to be in a situation where there is the need for removal and then kind of be scrambling to figure out what to do. And a lot of schools have threat assessments teams and kind of include police and council and mental health and student services all in one environment. But worth doing what works well for your institution, and also just to make sure you have a process where that's clear who makes the final decisions here. So when you have that process and you figure out what do you need to do, here, I think as Aaron alluded to, having a generalized policy, having hypotheticals, speculative beliefs, it is not sufficient here. So this is an important measure to have, but it's a fairly involved one, and could be problematic for the students. So you want to make sure there's something that you could have that's individualized, some analysis that you've done, something you could point to, especially if you receive a challenge or court kind of case to reinstate the student. And one other point that we thought was helpful to note, so the regulation mentions that the individual has to challenge their removal immediately. The preamble provides a little guidance here. It basically says that it really depends on the facts, but generally understood as occurring without delay as soon as possible given the circumstances. So we're not talking about within minutes here, but we are talking about something before days or certainly weeks to happen. So you want to make sure you have that ready to go if you have to take this step.
So a couple other questions, and then I'll get to supportive measures. But what about self-harm? That's tricky business, Scott.
It really is tricky. And it's important to note that the Title IX regulations do permit self-harm to be a ground for emergency removal when the threat arises from allegations of sexual harassment. So the key here is to remember that you also have obligations to consider and comply with under the Americans with Disabilities Act. So the ADA's version of this, their direct threat language, refers to a direct threat to the safety or health of others. And the ADA does not clearly encompass self-harm. So just flagging the issue, if you do get into a situation with self-harm, there could be tension between the two. You're obligated to comply with both. So just make sure you really do a thorough analysis under both laws to make sure that you're not discriminating against a person based on one or the other. Second, just to make clear, I think we talk about emergency rule in the context of students. Aaron mentioned this also is available for employees under administrative leave. And the regulations and the preamble make clear that the same due process protections that students receive with respect to emergency removals are available for employees if they were put on administrative leave for the same scenario.
All right, so supportive measures. We talked about interim measures. We were really focused on this idea of sending somebody home, right, before you got through the investigation and hearing. Supportive measures are something that are owned really by your Title IX coordinator, but it's good for everyone in the process to know what we're talking about. So as soon as an institution has actual knowledge of sexual harassment, even if it's not a formal complaint scenario. Remember, we're not actually to formal complaints yet. So we're just at the point now where an institution has that actual knowledge of Title IX, in this case, Title IX sexual harassment. And a Title IX coordinator is obligated to, and in our experience, is very happy to try to provide the parties with supportive measures. What do we mean by that? Non-disciplinary, non-punitive, individualized services that are offered as appropriate and as reasonably available. So there is this reasonability standard for institutions. This isn't like an accommodation discussion under the ADA exactly, right? But there is an expectation that if it's reasonable and it's non-punitive, that an institution will offer these supportive measures to the extent it's able without fee or charge to complainant or respondent, right? And at any point, before or after the filing of a complaint, or even where no complaint has been lodged. Such measures, what's the point? Such measures are designed to restore, preserve equal access. That's what the new rule says. I mean, in a more practical way of speaking, you're trying to make folks comfortable and protect one another and keep order, right, while you go through whatever remaining process you're going to go through, whether that be an informal resolution, which we'll talk about in a later session, whether that be through your formal investigation and hearing. But you've had an incident that's occurred, you've got an allegation that's been made, and if you're not going to send people home, there are a lot of things you may want to do to make sure that they can continue to enjoy and take advantage of your educational programs and activities while you work through the remainder of this process in a safe and appropriate way, right? So supportive measures can encompass a wide range of things. The idea is that the supportive measures should not unreasonably burden the other party. Remember, again, this administration is really focused on trying to treat both parties equally. So in the past, there were circumstances where institutions might put in place a supportive measure that could be viewed as punitive toward a respondent. So in other words, we're going to make the respondent take night classes instead of day classes, or only come to campus on the weekends, which could be a significant burden for some respondents and more than reasonable, right? And this administration said, look, if you haven't been through the process, if you haven't made a determination as to whether the allegations are true, you should not be putting into place measures that, while potentially supportive to the complainant, nonetheless are punitive toward a respondent. And so this administration has really emphasized that while supportive measures are certainly appropriate, and in fact, that an institution should undertake them, the big shift here with the new rule is that you have to be careful not to unreasonably burden either party. It's not just respondents, either party. So if you got to make a change with regard to class schedules, you need to try to do it in a way that has the least punitive impact on one party or the other, as is reasonable and possible. There are no doubt going to be circumstances where an institution goes out of its way and one party or the other still takes the view that the burden is unreasonable. But as an institution, you just have to do the best you can, keeping in mind the standard. Examples of supportive measures, we've got a whole screen of them here, and any Title IX coordinator that's been dealing with in this role for long is going to be familiar with all of these and others. If you're new to this, please just understand that these are the kinds of things that the school and the Title IX coordinator are often going to be working through and trying to provide for students, whether that be a complainant or respondent, and employees as well. Some of these would apply in the employment context. So counseling, changes in work locations or class locations, those types of supportive steps. Confidentiality. So there is an expectation that institutions will maintain as confidential any supportive measures they put into place, to the extent, and this is important, to the extent that maintaining such confidentiality would not impair the ability of the school to provide the supportive measure. So in other words, what they're saying is, look, sometimes you can't put a supportive measure in place without other people knowing, right? I mean, if you're trying to support a complainant and the solution is to slightly change the respondent's class schedule, well, the respondent's going to know, as are the respondent's teachers and classmates and others. And what the department is saying is, look, if sometimes to put in place a supportive measure, other parties are going to have to be aware that that measure has been taken. That doesn't mean you tell them about the underlying allegations or complaint, but they're going to at least be aware that that individual's class schedule has changed. And the department is saying, that's okay, right? That's okay, because otherwise you wouldn't be able to do anything really in the way of supportive measures. But apart from that, you should try to maintain confidentiality. And if you're not a Title IX coordinator, but otherwise involved in this process as an investigator, adjudicator, et cetera, just keep in mind these concepts of confidentiality sort of remain in place throughout the whole process. There's always an overriding expectation that to the maximum extent possible, confidentiality will be maintained. Finally, as stated previously, it really is the Title IX coordinator that owns supportive measures and is working in conjunction typically with HR or student affairs and counsel to decide what measures should be put into place, as well as the parties, I should say. All right, formal complaints. So remember we had earlier the big graphic, and we had at the largest level any kind of complaint of discrimination on the basis of sex. And then we moved in and we had complaints of Title IX sexual harassment. And then we had that orange box. And we said, now we're talking about formal complaints of Title IX sexual harassment. Everything we've talked about to this point in the presentation largely has applied and would apply when you get any kind of complaint of Title IX sexual harassment. Remember, Scott talked about what's the definition of Title IX sexual harassment. What do we mean when we talk about what's a sufficient response? We talked about interim and supportive measures, et cetera. Now we're closing in, we're focusing on that orange box, and we're talking about, what is a formal complaint of Title IX sexual harassment? Because recall, it's going to be the formal complaints that really trigger all that machinery that's present in the new rule, and in which many of the folks we assume who are listening in today are going to be participating. So there's a very specific definition. A formal complaint of Title IX sexual harassment means a document filed by a complainant or signed by the Title IX coordinator. Remember, Scott talked about situations where a Title IX coordinator, like where you have a serial predator, might actually end up signing the document. But it means a written document, right? A physical document filed by a complainant or signed by the Title IX coordinator alleging sexual harassment, so there has to be that allegation against the respondent, and requesting that the school investigate. So it's got to be in writing. It's got to be by either the complainant or the Title IX coordinator, and it's got to be alleging sexual harassment and requesting an investigation. So those are the elements of a formal complaint. And again, you may have complaints of sexual harassment that fall outside of this, and you still have all those obligations we discussed earlier, and you may still put interim and supportive measures in place, et cetera, et cetera. But if you get a formal complaint, then you move into that orange box, and you've got that whole new machinery with which you have to comply. By the way, the phrase document filed by a complainant, the department does talk about that. It means a document or electronic submission. So it doesn't have to be a physical. I said a physical document. It doesn't actually have to be a piece of paper signed. It could just be an email, right, from the complainant that satisfies those other required criteria. And to be clear, in the department notes, a formal complaint can be filed with the Title IX coordinator in person, by email, or by electronic mail. But an oral complaint, at least under the new rule, does not constitute a formal complaint, right? I mean, it has to be a document submitted to the Title IX coordinator that has the other elements we discussed earlier. The other thing that we should note is at the time of the filing of the formal complaint, the complainant, that's the person, remember in our definition, who is alleged to be the victim of the, or is the victim of the alleged sexual harassment, the complainant has to be participating in or attempting to participate in an education program or activity. And the department sort of justifies this limitation by tying it back to Title IX and the notion that Title IX prohibits sex discrimination in programs or activities. So they're saying, so, complainant has to be involved in those. But remember, as Scott and I have discussed previously, you could still have a policy that would extend to and provide relief for individuals who are subjected to sexual harassment, even when they're not participating in a education program or activity. It just wouldn't be Title IX sexual harassment, and it wouldn't be a formal complaint of Title IX sexual harassment. It would have to fall under that alternative process. Let's see. The last thing I just want to show you, you're going to see this chart quite a bit. So the department says if you have a formal complaint of Title IX sexual harassment, then there are certain things you have to do, but primarily you have to comply with all of these requirements that are set out in the new rule. And specifically, and you'll see the citation at the bottom of your page. By the way, I should have highlighted earlier, throughout the presentation, we have, where appropriate, we actually have the legal citations at the bottom. So most of this machinery is located in 34 CFR 106.45, And if you have a formal complaint, then your process that you put into place has to have all of these elements. And that's really, I mentioned earlier, that's really what this new rule is about. It's saying when you've got a formal complaint, you've got to have a policy on the books. And your policy has to include all of these different elements, right? And there's a lot to it. So the rest of our training sessions, the next 5 modules that you, hopefully you'll go through and that we're going to present and make available, really are focused on walking through these different elements you see on the screen right now. So we've got a presentation where we'll talk about, these core requirements and dismissal and consolidation. And we've got one where we talk about investigations, and we've got a career investigator who's going to join us. And we've got one where we talk about hearings and another appeals. And we have a retired judge who's going to join us for those, which we think will be great. So we hope you'll tune in. There's going to be a lot of good information. For this presentation, the only one in this process that we're going to hit on here at the end, and you're almost done, by the way, just 2 more sections left in the syllabus. At the end here, we're going to talk about record keeping. So with that, I will turn it back to Mr. Goldschmidt.
Thanks. So just to really briefly go over record keeping obligations under the regulation. So in addition to anything as required by your institution's record retention policy, if there's a formal complaint of Title IX sexual harassment, the institution's under an obligation to maintain records for 7 years. So these records include records of actions taken, including supportive measures, the basis for the school's conclusion that its response was not deliberately indifferent, which hopefully you have a sufficient documentation of, documentation that the school took measures to restore preserved equal access, and if you didn't provide supportive measures, reasons to explain why. So hopefully these are things that you would be keeping in the regular course, maybe not for 7 years, but you would just have to document your actions for the institution. But this regulation specifically enumerates this and the obligations on the next slide. So if there's an adjudication, just really briefly, records also have to contain any determination regarding responsibility, audio-visual recording of the transcript, which is a requirement of the adjudication that we'll discuss, record of the disciplinary sanctions, record of the remedies provided, record of any appeal, and a record of any informal resolution and the results of that informal resolution. And last on record keeping, so in addition to those requirements, there's also a requirement to keep and publicly make available on your website materials used to train your Title IX coordinators, investigators, adjudicators, and any person who facilitates an informal resolution process. So to the extent that these videos are used for your training, please post them on your website so that you comply with this requirement. But as we mentioned before, this cannot be the only training that you have. So make sure you post those materials as well with regard to other elements and specific institutional policies. Last 2 additional considerations. The first deals with retaliation. So hopefully your institution already has a process and expectation that retaliation is prohibited. The regulation specifically states that retaliation is not acceptable. No school or person can intimidate, threaten, coerce, discriminate any individual for exercising their Title IX rights, or because that individual made a report or complaint, or participated really in any part of the process through testifying, assisting, participating, refusing to participate in any manner. Retaliation is prohibited as it should be, and you should have a part of your policy that reflects this expectation. And last, Title VII. So this will be mostly relevant to your HR folks, and really trying to square Title IX and the requirements that employees need to go through the Title IX process with established processes of Title VII. So Title VII prohibits discrimination in the workplace, and has been interpreted that it prohibits sexual harassment. So in the preamble, the department explains that that they're aware that Title VII imposes different obligations with respect to sexual harassment, including different definitions of sexual harassment, different knowledge standards, and just kind of basically explains and really told everyone that recipients need to comply with both Title VII and Title IX. And they're in response to commenters' concerns, their position was there's no inherent conflict between Title VII and Title IX. So the institution should have no issue complying. Whether that's the case in reality, maybe those are the few HR professionals that will beg to differ with that. But the department's position here is there should be no conflict, so comply with both.
Yeah, it's but boy, if only we could all have that kind of power, right? I love that authority. There is no conflict. These are not the droids you're looking for, right? At any rate, moving right along. So we're here at the end, and we just wanted to highlight for folks some additional resources. First of all, the Office of Civil Rights indicated, and the department has indicated that on a go-forward basis, when it's got guidance around this rule or interpretive guidance, et cetera, it's going to post it on this blog. Again, if you've got the PDF of the slides, you can click on that square right there, and it'll take you to the blog. It's not hard to find, though. If you just Google OCR, I don't know, civil rights blog, it ought to pop right up. Also wanted to highlight for folks, we have a comparison document that we created that you may find useful. So if you look at that Federal Register document we highlighted earlier, which is where the new rule is located as of right now, and even after the new rule comes out, what you can't see is how it's changed, right? Because the Federal Register just shows you the new text, but it doesn't actually show you in the context of the existing regulation what's different. So we created a comparison document. If you're a counsel or if you're a Title IX coordinator or a curious adjudicator, please feel free. This is located on the same page where the slides are located. And if for some reason you cannot find the slides or this comparison document, just shoot me an email or Scott an email and we'll get it to you. 2 or 3 other things and then we'll be done. We have a higher education webinar series. They are all free and they are on demand if you can't make the live versions. We usually track the academic year. So we start in August and go through May, and we cover all different kinds of higher ed topics, including, you'll see here in May 2020, we did a 3-hour version of this whole series, sort of condensed, that we then expanded into this 6-part training series. We also have a blog. You're welcome to sign up. We talk about lots of different stuff, a lot of writing about the CARES Act recently for institutions of higher education, but we also cover Title IX and other matters. And occasionally we put out, again, free tools that we think would be useful to institutions. We have an alert that we send out and use. And then, and this is an example, we did a reporting guide for the borrower defense reporting requirements, which counsel may find useful. Finally, there's some additional information. I'll just stop here. Extended bios for Scott and myself and a disclaimer reminding you that we are not your attorneys. But I will end this by saying I hope you will stick with us and go through the remaining modules. It is really our pleasure to bring this information to you. We know this is a lot to take in schools, particularly in this time of COVID-19 with folks all at home, trying to figure out how to put all this training together and get it to the people who may be involved in these processes. We know is difficult. So we hope this is helpful. And last but not least, I'll say for myself and for Scott, for everybody out there, please be safe and be well.